I just said? Critics of Guantanamo seem to believe that if we put our vaunted civilian justice system on display in these cases, then we will reap the benefits in the coin of the world opinion, and perhaps even in part of what the world wishes us to do. Of course, we did just that after the first World Trade Center bombing, after the plot to blow up U.S. airliners over the Pacific, and after the embassy bombings in Kenya and Tanzania. In return, we got the 9/11 attacks and the murder of nearly 3,000 innocents. True, this won us a great deal of goodwill abroad. People around the globe lined up for blocks outside of our embassies to sign the condolence books. This is the kind of goodwill that we can do without, end quote. What Michael Musaki, who is an Attorney General of the United States from 2007 to 2009, is highlighting in 2009 is the fact that when we tried to have open trials for terrorists, this led to more terrorism. Now, while this is not a direct disadvantage that we are claiming from the affirmative team's policy, it's simply a mindset that this is not a policy that we need to be enacting in the current system. In this first negative constructive, what I'm going to be doing is outlining the reasons why the affirmative team's plan should not be passed. And I'll be going through this with the philosophy that we should have the best options available. The best options available. We are not going to be arguing in today's debate round that military commissions are the best way to try terrorists, because that's not necessarily backed up by the evidence. Rather, we're going to be taking a more reasoned approach that we don't need to choose one or the other. Both have their strengths, and we should have the best options available. In fact, Robert Chesney, who the affirmative team cited in their first affirmative constructive as a critic of military commissions, ultimately concludes that we should not abolish them. He says this in February 26th of 2018, quote, "None of this is to say that commissions should be abolished as to all circumstances and for all time. They should not be. Commissions arose originally because they combat circumstances in which a commission may provide the only realistic prospect for doing justice, and at least that to the degree they should remain available." End quote. So even the affirmative team's authors, who criticized military commissions, end up on the side of the negative team, that they're not the best option to try terrorists in all cases. However, there are certain instances where they should be an option. And this is the stance the negative team will be taking in today's debate round. We will be defending the option of military commissions through a couple of things, but I'll be first critiquing the affirmative team's definition of justice, basically implied in their first justification. Then I'll be talking about the first justification, the statistic they cited of the comparison of the convictions between military commissions and federal courts. Pardon me. And then I'll be looking at a significance point and a couple of disadvantages, ultimately showing how it's best to maintain our military commissions. I'd like to talk about the idea of justice right now. It's commonly held that justice is getting what you deserve. However, the negative team's standards or ideas of justice don't necessarily back this up. Their first point was that it was efficient, but as clarified in cross-examination, this is not their only warrant to why justice is better served in Article 3 courts. They said that they are more effective. However, to truly say that they are more effective, they have to prove that in all those circumstances that the criminal or the terrorist got what they deserved. Until they can show in every specific case that justice was served, then you can't just say a harsher charge automatically equals justice. That's not how our criminal justice system has worked, and that's not what we should adhere to with a definition of justice. The next point I'd like to talk about is they said that there have been 600 criminals, or roughly, or over 600 actually, convicted in federal courts, whereas there have only been 8 convicted in military commissions, and they said that 4 of those were overturned. However, that's a little bit of a misleading statistic. Robert Farley wrote on February 12th of 2010, quote, "New York University Center on Law and Security has been tracking such cases for years and throws a wide net. In its terrorist trial report cards from September 11th, 2001 to September 11th, 2009, it finds that the Department of Justice has indicted 828 defendants on terrorism-related charges. Of the 593 that have been resolved, 523 were convicted on some charges either at a trial or by plea. Terrorism-related can be a broad definition, though, and can include immigration violations, giving false statements, and other relatively minor charges. There are probably less than a dozen cases against people in the Islamic jihadist framework who have been convicted in federal courts of serious terrorism-related crimes, comparable to many of the Guantanamo detainees," Greenberg said, end quote. Ultimately, what this rather long card of evidence is alluding to is the fact that in Guantanamo Bay, when we compare apples to apples, similar terrorists, the conviction rates are quite comparable. The next point I'd like to talk about is the significance argument of the fact that there is no harm to justice in the current system. They have not proven that there is any harm to justice in the current system. And if there is no harm, then there is no impetus for change. It is up to the affirmative team to show a tangible, concrete harm to United States interests under their policy. But next, I'd like to talk about a couple of disadvantages. We already talked about the disadvantage of removing a valuable option from Robert Chesney, saying that the military commissions should at least be on the table. So that would be our first disadvantage to the affirmative team's policy, removing a valuable option. However, our second is that it could be a danger to society to bring terrorists to America for trial. This endanger to society is our second disadvantage. The National Review wrote on February 24th of 2016, quote, "It stands to reason that a subsequent administration would use detention on American soil to argue for detainees' rights to trial in federal courts. And it is not all that difficult to envision that justices hostile to the notion of indefinite detention will order the release of detainees from custody, possibly onto American soil." Quote. What this author is highlighting is that there are some lax justices that could potentially let terrorists onto American soil because they oppose indefinite detention. So the second disadvantage is there is a danger to society, a threat to society. And then the last disadvantage that I'd like to talk about is that there is a burden to state facilities, a burden to state facilities. U.S. Representative Scott Perry wrote on April 28th of 2016, quote, "I've happened to visit Guantanamo Bay, where the taxpayers pay dearly for a very specific court facility that handled these very dangerous people in a classified setting. Where is that going to happen, and who's going to be paying for that yet again? Right now, all of us pay for Guantanamo Bay, but if you move them state by state, facility by facility, it will be the taxpayers in those local locations that will bear the entire burden." End quote. What he's alluding to is the fact that we have built a system to specifically take some terrorists out of the American soil, and to completely abandon that would overburden the taxpayers. So those are just a couple of disadvantages with the affirmative team's policy. But the last thing I'd like to point to is that federal courts are not perfect. Federal courts are not perfect. I'd like to read you an example of the trial of Ahmed Galahani. Now, I don't have time to read this entire example, who is reported by Danny Golinetz, who wrote on March 12th of 2013. But he's basically explaining how a terrorist was tried in a federal court, a terrorist that had multiple murder charges. However, those were all dropped, and he was only convicted on one charge. Now, it's the affirmative team's contention that because these 9/11 hijackers have not been convicted of all the crimes that they committed, even though they are in indefinite detention, the justice is still not served. However, in the case of Ahmed Galahani, the same holds true. So by the affirmative team's definition of injustice, there is injustice in the federal courts. They're not perfect. Now, it's not the contention of the negative team in today's debate round that military commissions should hold all trials of terrorists, because they're not designed or equipped to hold all trials. That's why we've had a varied approach between both federal courts and military commissions. This is the way it should be. This is the way the affirmative team's own authors advocate for having the most options on the table to truly serve justice.